Hi friends, this is Raghu, advocate.
Fresh law graduates in judiciary. Was that been a blessing or it has been a blunder? Let us discuss this thing in this video. Wherever been the judicial experience, this is the main debate which has been going on. Experience and the fresher and where the compromise position might be getting. In the view of the experienced advocate, they have an ample amount of wisdom. They understand legal nuances through years of practice. This is what has been the debate in the experience perspective. Whereas in regarding to the fresher, they bring modern legal theories. That's what has been these people has been doing in the modern advocacies. They bridge the knowledge where they will bring the innovation into the legal system. That is what been debated in the fresher perspective mind. The compromise was being the mentorship program which can bridge the gap between the fresher and the experienced. By pairing new graduates with experienced judges, they might create the balance. This is what being the main perspective. Recently in 2025, there has been a writ petition regarding the question of fresh graduates becoming a civil judge in junior division, wherein the bench comprises of B.R. Gavai, A.G. Masih and Chandran from hearing the panel, whereas the petitioner is being the All India Judge Association, wherein we had discussed recently that there is a writ. The petitioner All India Judge Association has an amalgamation of different things wherein covering the pensions and promotions and also the eligibility criteria. What is the central question in this thing? Whereas the present system is allowing the fresh law graduates are directly applying for civil judge examination without practical experience, but in the old system wherein there used to be at least 3 years of practice at bar before eligibility for judicial examination, and the main and the core debate here is, can classroom theory adequately replace courtroom wisdom for judicial officers? This is the main question has been asked. That's why there has been a stay in the recently held exams of the judiciary exams in various states. Here, as an Amicus Curiae, Senior Advocate Siddharth Bhatnagar has been appointed, wherein in reference to the 1993 case, cited the landmark All India Judges Association case of 1993, wherein bookish knowledge is insufficient. They arguing that theoretical knowledge cannot substitute for practical experience. This is what is being advised to the court. Learning in the courtrooms by observation or by justice or by through empathy or through strategy. This is what is being said while any junior advocates, while they are going to the courtrooms, these are the main things they have been arguing, that they observe and by watching seniors and how see the framing of the arguments and handle objections, and in the same way understanding the litigation and concerns and anxiety in the first hand, while in the strategy there has been tactical approach to different legal scenarios, and while bringing the justice they has to grasp the practical application of the legal principles. This is what been stated by them. Previously, Supreme Court has directed all states for mandate minimum practical experience, and there is a 3-year rule wherein minimum practice period established at 3 years before judicial eligibility. The rationale rationale behind this is courtroom experience deemed to be essential for developing judicial temperament. Friends, and in about the implementation, states has to incorporate this requirement into judicial service rules. This is what has been originally directed by the Supreme Court. When Supreme Court has been directed, so there is a U-turn wherein Justice K.G. Shetty Commission recommended significant changes to the judicial recruitment. Talent has to be attracted, and as there is a decline in the interest in the judicial services among the graduates, these waiting period barred 3 years practice requirement deterred bright candidates. So there is a compromise over here, and so in 2002 there is an reform solution wherein the direct recruitment, fresh law graduates are permitted to apply for judicial positions, and the judicial training of mandatory 1 to 2 years training program for selected candidates. In the end, the appointment wherein a position civil judge junior division after completing training. And here right now the main observation is regarding the theoretical and the practical knowledge, whereas in the theoretical knowledge there has been regarding the legal principles and the case, precedents and statutory interpretations and procedural rules. This has been thought in the theoretical knowledge, whereas in practically there is a lot of court dynamics, witness assessment, evidence evaluation, quick decision making. This you will be seen through practical experience, which is very essential in making a decision. So there is an challenge in the training institution wherein inadequate infrastructure in many states, okay, and faculty shortages has been observed in while training new judicial officers, whereas the other key point is the curriculum gaps. Training often emphasizes theory over practical courtroom, which is mandatory, and the duration is also like 1 year training may be insufficient in developing judicial temperament. This 4 has been observed. And also regarding the judicial quality, where it has been observed that 65% cases has been overturned, while there is a higher percentage of judgments from inexperienced judges being overturned on appeal, whereas been 44% it has been observed that there is a procedure errors, where it has been the percentage of the cases with procedure irregularities has been done by the direct recruits, and there has been a 28% efficiency gap, lower case disposal rate while compared to the prior advocate experience. This is what has been observed, and there might be an potential compromise solution, like there should be an hybrid experience or specialized LLM wherein judicial services with extensive courtroom apprenticeship component and mentorship system wherein fresh recruit paired with senior judges wherein their experience and extensive guidance it will be shared among themselves, and tied entry wherein different entry path based on experience with corresponding responsibilities, and mainly in this hybrid experience wherein 1 year bar practice plus 1 year judicial training before appointment. This might be an potential solution. The evolution of the judicial appointments in India, wherein the Indian judicial appointment system has undergone significant evolution, wherein the debate of whether courtroom experience should be mandatory for judicial appointment. Recent discussion in the Supreme Court revealed changing perspective on importance of practical experience versus theoretical knowledge, wherein the changing landscape of the judicial service, in earlier period there used to be an low pay and limited incentives in judicial service, which has made it less attractive to experienced lawyers, wherein the current scenario in 2025 improved compensation have transformed judicial service into coveted career path, and the future outlook, lawyers now willing to wait 3 years to qualify for judicial appointments. This is what has been said in the recent debate, while wherein some of the high courts are favoring practical experience, wherein 2 courts has been opposing. Most high courts are saying that now advocates for prior practice has been required. On an average, 3 average years has been recommended in practice from the most high court, wherein only Sikkim and Chhattisgarh has been rejecting these requirements. This debate has been further been divided between various high courts, wherein Punjab, Haryana and Andhra Pradesh, Assam High Court and Uttarakhand High Court are pro towards the practice requirement, whereas the Sikkim and Chhattisgarh has been against this practical requirement. And there has been some of the illusion of practice, wherein some simply register in the bar without actual court appearances, and the judicial appointments entering judiciary without true practical knowledge and practical experience and paper experience, like accumulating years on papers without meaningfully courtroom exposure, has been a main concern these days, and minimal engagement like the limited basic procedure matters like seeking adjournment. Now, Justice Masih is revealing these cases like top law graduates wherein excellent academic credential from prestigious institutions and influential backgrounds like son of an established senior lawyer, and the bar registration wherein formally registered as practicing advocate, 0 court experience like never actually appeared into court during these 2 years. Justice Gavai's humorous insights wherein lawyers in Nagpur who wanted to write book title 100 Ways of Seeking Argument, like highlighting how some lawyers avoid substantial legal work, wherein the cultural critic really reveals accepted practice of minimal engagement with legal process, and the quality concerns like demonstrates why paper experience alone is insufficient. Now, the proposed solutions to verify this practice like judicial certification, verified court appearance and structured training. This has been the proposed solution, and wherein the hybrid approach like 2 years of verified practice in court experience and 1 year of institutional training, a while balancing approach where combined practical skills with theoretical skills, which has been recommended through this hybrid approach, and the main path forward, growing consciences and ongoing deliberations, and wherein the practical reality. Most stakeholders now agree that courtroom exposure is essential before judicial appointment. The case continues as Supreme Court consider various perspectives and solutions, and the practical reality. The court represents a battlefield of law, emotion and human life that requires practical experience. This is what has been concluded.
Now, based on this, what you will conclude, if you want more like this type of videos, like, share and subscribe.